Welcome to Conversations. I'm Suresh Kochata. For a long time, it was on the political back burner. But finally, yesterday, the Supreme Court allowed the subgroups within the 15% scheduled caste quota. The landmark judgment of the Supreme Court permitted states to sub-categorize caste within the scheduled caste based on socio-backwardness and, of course, the degree of underrepresentation in government jobs. So far, this prerogative was with the union government, which recommended to the President of India for this particular reservation category. Now, what this judgment will do? Of course, it will ensure that the larger pie of the Dalit quota, that is the SC quota, will go to the actual backwards among them. In fact, also ask the state governments to devise suitable criteria to bar the creamy layer among SCs and STs, something that was till now only with the OBCs. Of course, creamy layer by itself is a big joke because the state governments keep changing the criteria for that. The 6:1 majority ruling, led of a bench led by Justice Chandrachud, and of course Justice Gavai, Justice Vikram Nath, Justice Bela M Trivedi, Justice Pankaj Mithal, Justice Manoj, Misra, and Justice SC Sharma, overruled a 2004, that's a 20-year-old judgment of a 5-judge bench in the EV Chinnaiah versus the State of Andhra Pradesh, which had then held that the SCs were a homogeneous group and therefore could not be sub-categorized. In fact, Justice Trivedi dissented and said that the Chinnaiah judgment was constitutionally valid, the only judge to do that in this particular bench. Of course, to get rid of all the politics that would go with it, the quota within quota, actually we'll see a lot of new things. The court clarified that the sub-classification of caste within the scheduled caste cannot be based on the government's whims and fancies or political consideration. We'll have to see how this works out because it's not going to be easy. In fact, the court said that the sub-classification of the most backward among the SC community must be based on empirical data, both quantifiable and demonstrable regarding the backwardness. How many state governments have this data and who are willing to walk the extra mile to get it? That's going to be a big, big question. The logic behind the court's suggestion of keeping the creamy layer out is the children of, say, civil servants, for example, and those among others among the SCs who have moved up the socio-economic ladder and have received good education should not be getting this quota anymore. In fact, as I said before, that this present creamy layer exclusion policy is applicable only to the other backward classes as of now. But with this, there's going to be a huge, huge change in the way the SC categorization is going to be done. Justice Chandrachud authored the 140-page judgment for himself and Justice Misra, who agreed with him. Of course, the other judges wrote their individual bits, but more or less everybody agreed with what was done. 6:1, that was what it is. In fact, it was Justice Gavai and CJI who agreed with each other, making the 6 of the 7 judges concur with this constitutional responsibility and permissibility of sub-classification of the scheduled caste community. It was Justice Gavai, the lone Dalit judge on the bench, who mustered enough courage to hold that those among the SCs and STs community who have got top jobs and top positions in civil services and other ranks and have risen in socio-economic strata must be excluded. Then that is going to be a big political game because till now it was a creamy layer who were knocking off all the benefits, keeping the poor of the poor, the discriminated of the discriminate actually down in the dumps. In fact, Justice Mithal took the creamy layer exclusion to a different level altogether. Reservation, he said, if it has to happen, should be limited only for the first generation or just one generation. And if any generation in the family has taken advantage of it, then they have achieved that socio-economic status. And therefore, reservation should not be available to them. This is something I had said a long time before. I think almost a couple of months ago, I had spoken about this on many news channels. Why should a generation that has already got reservation get it again? Their children would naturally do well, isn't it? And this is what it is. In fact, this is Justice Gavai actually wrote a 281-page opinion on this. In fact, the criteria to evolve the policy for identifying the creamy layer even among the scheduled castes and scheduled tribes so as to exclude them from the affirmative action should be done in a professional manner in a non-discriminatory manner. But that remains to be seen, because no state government would like to keep this particular limit very high. They will bring it even lower and lower so that more people can get out of it. And then they will increase so that more people will get advantage of it. This is what they've been doing all along. In fact, cautioning the states that the sub-categorization has to be based on empirical data. Chief Justice Chandrachud said, when the action is challenged before the High Court or the Supreme Court, the state will have to justify the basis of its action. Which means the courts are actually anticipating that there will be a flood of cases that will come to the courts after this is kind of implemented at a state level. And the state will have to justify this on basis of empirical data that they have gathered. Easier said than done, if you ask me. The state cannot act merely on its whims or fancies, said the judges, at a matter of political expediency. And that's what they will do. That's what they've been doing all along. The decision of the state is amenable to judicial review, and the state must provide justification and rationale for its determination. Now tell me, which state will do this? No state will do it. It will be arbitrary. They will do it as per the whims and fancies without any data, and then come to the court, and it gets stayed, and that's exactly what the states want. They want the entire thing to be stayed so that nothing will happen. In fact, if you remember, in Telangana, it was Mandakrishna Madiga who has been fighting this for sub-categorization of the scheduled caste community for the last almost 3 decades. In fact, at last year's public meeting with Madiga on stage in Secunderabad, Prime Minister Narendra Modi announced that he supported this move, the demand. And emotional Mandakrishna Madiga couldn't hold back his tears, and he received a consoling hug from the Prime Minister. Now think about it, how many politicians that PM Modi has met have got this hug? Very few. The passage of time, of course, has blunted the strident opposition that existed to the controversial proposition of sub-categorization. Because the implementation in states for years had made actually strong, hostile subcaste reconcile the possibility, which in turn made the political parties shed fears of a backlash from the stronger communities. And that is what the stronger subgroups within those communities. But this is true only about states whom the Supreme Court had empowered to carry out these sub-categorization. What happens from here on is the most important thing. Because the Supreme Court verdict has basically lobbed the kind of issue into the court of the center. The union government, the BJP-led NDA government, is expected to spell out its stance on sub-categorization, and it has done past. And that is exactly what it did in court, which enabled this particular judgment to come. If this had to be done at the central level, then Prime Minister Modi would have been in soup. But now that it has gone to the state level, the states will have to deal with all this. In fact, that is exactly what it is. In fact, during the Telangana Assembly election campaign, Prime Minister Modi actually announced his decision that he would send out a signal in favor of sub-classification to the court which is hearing it. And in fact, constitute a high-powered committee, in fact headed by the Cabinet Secretary, ahead of the Lok Sabha polls. Whether that happened in the background, we are not really sure. Now that there is a favorable verdict, the government actually will now have to deal with a contentious issue of sub-categorization at a state level. Take the Telangana government, for example, because I am from Hyderabad, so I speak on Telangana government. It now faces the very tough task of identifying the most backward among the SCs. And the government will have to take appoint either a commission or conduct a survey to identify the most number of SC caste and sub-category caste from that, and their proportion in what the SC calls the total SC population in the state, and then what benefits have they got? Do they have jobs? Do they have education and all that? And keep all that within the 15% the scheduled caste quota limit. They cannot go over about it. Moreover, the Telangana government will have to start from scratch, as they have nothing with them right now. Because as the earlier sub-categorization into 4 categories, A, B, C, D, was done in the United Andhra Pradesh by Justice Ramachandra Raju Commission, which was then set up by the TDP honcho, Chandrababu Naidu, who is another big advocate of sub-categorization. In fact, the Chandrababu Naidu government way back then, if I remember right, I think it was 1996, had gone ahead with the sub-categorization. But later, it was struck down by the same Supreme Court and then in 2004. And now the Supreme Court says it's all hunky-dory, please go ahead. Now with the Supreme Court clearly stating that any subclassification of the most backward among the SCs must be backed by empirical data, any exercise by the state will have to not only stand legal scrutiny, but also keep the subcaste happy and not kind of get the issue from boiling over into something big. While the subclassification may have cleared a legal hurdle, the subclassification by itself within the scheduled caste community, once implemented, will see a whole new ball game with hundreds of cases that will be filed in the courts. And that will be a bigger mess than what it is right now. Let's see how it goes from here. Maybe we'll have to wait for a few months or maybe a year to see how this all pans out. Till then, keep watching. Jai Hind.